This prosecutor, Jack Smith, who I call Jack the Ripper Smith, he's a very bad guy, in my opinion. I want to tell you quickly, as I've told you in the distant past, he's had two major defeats when it came to public corruption cases when he headed the public integrity section of the criminal division over at the Department of Justice. He was the big Mahaf, and he blew these cases. Supreme Court overturns Bob McDonnell's corruption convictions. This is Politico from 2016. A unanimous Supreme Court, it was 8-0, one justice recused, has overturned the corruption convictions of former Virginia Governor Bob McDonnell, ruling that federal prosecutors relied on a boundless definition of the kinds of acts that could lead politicians to face criminal charges. So he takes a bribery statute and expands it so preposterously that even the Supreme Court says, you can't do this. The justices set forth a straightforward rule. Setting up a meeting, calling another public official, or hosting an event does not, standing alone, qualify as an official act. An official act in return for a favor, like a trip or something like that. So they destroyed Bob McDonnell's career, destroyed it, bankrupted virtually the man, ruined his marriage, and then, oops, 8-0, the Supreme Court says, this is outrageous. Who was behind it? Jack the Ripper Smith. Here's another one. This is from ABC News, 2012. John Edwards jurors say evidence wasn't there to convict. We're talking about a case in which John Edwards or his people asked donors to contribute money to put up his pregnant girlfriend in an apartment to try and cover it up during the course of his election. And what did Jack the Ripper Smith conclude? That's a crime under the federal election code. How? Well, it contributed positively to his campaign. It's sort of the Alvin Bragg argument. So what did the jury say? There were 6 counts brought against Edwards. Quote, there wasn't enough evidence there, one of the jurors said, adding that she did not believe the case should ever have come to a courtroom in Greensboro, North Carolina. The jurors with whom ABC News spoke believed the prosecution had not made its case, but said there was a small group of holdouts convinced of Edwards' guilt. I felt like the evidence just wasn't there, the juror, Teresa Fuller, had mentioned. It could have been more. It could have been a lot more than what it was. So he brings a frivolous case on 6 charges, again, takes a statute dealing with elections and pulls it out of existence. He's rewriting these statutes not because he wants to do justice, because he wants to do injustice. He has the wrong mindset, this man. He targets people, he hunts them, and then he destroys them. Now, they shipped him off to The Hague where he could chase down genocidal maniacs. But before they did this, he was the acting U.S. attorney in the Middle District of Tennessee. Where's that? Nashville. The acting U.S. attorney. He assumed he would become the U.S. attorney. But then who became president of the United States in 2016? Actually, 2017 he was sworn in. It was Donald Trump. Donald Trump did not appoint him as the U.S. attorney, Jack the Ripper Smith. He appointed somebody else. So Smith resigned. He wasn't happy. So you can see, and this is the first you probably heard, unless you listen to my radio show, the man has a chip on his shoulder. The Espionage Act from 1917 to last week was never, ever used against a former president or a former vice president or even a former cabinet secretary. That was never the intention. The law is 106 years old. It was not intended to be used this way to criminalize document cases, whether the documents are classified or not. It doesn't matter who created them. They're in the possession of the White House, the president, his staff, or whomever. The Presidential Records Act, which was passed in 1978 and instituted effectively in 1981, has no criminal penalty. So you can't start with the Presidential Records Act and all of a sudden say, okay, let's move to the Espionage Act. Even before there was a Presidential Records Act, the Espionage Act was never used against Lyndon Johnson, who directed his staff to remove top-secret information involving the Vietnam War and his illegal taps on Nixon's phones. The war was still going on. That information was taken by a staffer to Director LBJ, was eventually turned over his library, where they sat on it for decades. Nobody even thought about charging anybody with the Espionage Act. And there are other cases, too. I mean, you're talking about Hillary Clinton. The Hillary Clinton case is so obvious, she wasn't even a president or a vice president. The Presidential Records Act doesn't even apply to her. If you're going to apply anything, it's the Espionage Act, and even that doesn't apply, in my humble opinion, but okay, fine. They'd even investigate her for obstruction, even though she destroyed tens of thousands of emails, permanently. Even though they destroyed her past cell phones with hammers. You ever try that? I'm sure that's not easy. So, they never investigated her for obstruction, never investigated her for perjury, even though there were existing subpoenas from the House Oversight Committee under Chairman Jason Chaffetz, and he's talked about this. So she gets away scot-free, no federal grand jury, no warrant, no SWAT team. Why? Bill Clinton in the Sox case. For years, he's recording and top-secret information. He wants to keep it for a book he's going to write and posterity, his legacy, and all the rest of it. Keeps it in his socks drawer. Leaves the presidency, takes it all with him. Takes it all with him. Nobody charged him with violating the Espionage Act. Nobody even thought about it. So what happened? So Judicial Watch walks in and says under the FOIA, Freedom of Information Act, National Archives, you go get those tapes. We want to look at what we can look at. Goes in front of a federal judge in 2012, 11 years ago. In Washington, D.C., she's appointed by Obama. She's a leftist. She went after Manafort. She went after Stone. And what does she rule? She rules, I can't do anything. My hands are tied. Even judicial review, I can't order anything. The Presidential Records Act says that these documents belong to the president, the ex-president, and it has very broad authority in that respect. So I can't order the National Archives. He has the right to segregate what he believes is private and what's not, and there's nothing anybody can do about it. Wow. The government's position, the Department of Justice, the prosecutor's position, was that that was the correct decision because they fought Judicial Watch when it came to the acquisition of this information. So there never should have been a grand jury on the documents case, ever. There should never have been a violation of attorney-client privilege under the crime-fraud exception. It should never have occurred. There should never have been a search warrant. There should never have been FBI SWAT team raid on President Trump's house. Obstruction. Obstruction, illegal criminalization of a document case here. If the government really felt it had to do something about all this, they follow the civil track. They go to a judge, they get an order, a civil order, where if they can convince the judge, he orders President Trump and his people to turn over all the documents. So that judge would have to ignore the Presidential Records Act, but let's play along. Let's say the lawyers say, no, we're not going to do that. You don't start a criminal investigation, as Bill Barr suggests. We move from the Presidential Records Act to the espionage. No, you don't. You can go to the judge who issued an order and say, okay, we need civil contempt. You need to hold these lawyers you need to hold them in contempt. They never did that. They didn't follow that route. Why? Because they want to put Donald Trump in prison. That's why. Hillary Clinton, the Espionage Act. She retained classified and unclassified information for a period of years. She put a private server in her basement. And that was illegal as it was. Intentionally bypassed the government's security system. She lied about it repeatedly. Destroyed thousands of emails permanently, as I said. Destroyed cell phones permanently, as I said. Never criminalized under the Espionage Act. That is, they talked about it, but they said, we would never prosecute anybody under this act. Never investigated for obstruction. No warrant. No SWAT team. Nothing. Lyndon Johnson, nobody even thought of the Espionage Act. Joe Biden, as a senator, stealing information from the Senate SCIF, spreading information in 4 different locations, not saying a word about it for decades. For decades. No Espionage Act consideration there. If there was, he'd be indicted today. Jimmy Carter's documents? Nope. Mike Pence's document? Nope. Bill Clinton's tapes? Nope. Former presidents and vice presidents? Former Secretary of State? Nothing. And I have a question for former attorneys general, Bill Barr, others. Did you ever read classified information in your vehicle?